Hey boys and girls, Todd Vandermeid back for another edition of Freedom Steel. We have some breaking news that Illinois is going back in front of the United States Supreme Court. So back to you after the intro. That is right, boys and girls. Todd Vandermeid, former NRA contract lobbyist, Illinois gun law guru, and Illinois is back in front of the United States Supreme Court for the second time in 2 weeks. So yes, boys and girls, you heard me correctly. Illinois is back in front of the United States Supreme Court for the second time in 2 weeks. You're saying, Todd, what are you talking about? Well, we'll get to that in a minute, but right now, the consolidated cases out of Southern Illinois have sat there and filed a cert petition before judgment in front of the United States Supreme Court, with Paul Clement and Aaron Murphy taking the lead as attorneys. All four groups in Southern Illinois have filed a motion for certiorari in front of the United States Supreme Court, citing how bad the Seventh Circuit decision is. So I'm not going to dive deep into the weeds on this, but they throw some sharp elbows in here in trying to point out. They say that the decision below defies this court's precedent and creates a circuit split. And so they're trying to push every angle that they can to get up to the court, to get the court to take this case. They said House Bill 5471 can only be understood as a form of protest legislation designed to defy rather than comply with Bruin. Neither the Second Amendment nor Bruin may be particularly popular in certain jurisdictions, but that is no surprise when it comes to the counter-majoritarian protections in the Bill of Rights, and it is certainly no excuse for failing to comply with the Constitution. The Seventh Circuit should have said as much in chastising the legislature and vindicating the rule of law. Instead, it upheld House Bill 5471's blunderbuss attack on the Second Amendment, and it did so only by defying this court's precedents and creating a circuit split. So there you have it. They aren't pulling any punches, and they are going at this. But as I said in part of my opening, this is the second time in as many weeks that some of the plaintiffs from Illinois are in front of the United States Supreme Court. So let's rewind a little bit. If you go back to the Cargill case, remember, Cargill is about bump stocks. And with that, when I heard that the Cargill case was being taken up on appeal and the Supreme Court was actually granting cert for that case, I had this thought. How do you talk about bump stocks without talking about semi-autos? So why don't we sit there and just use that to break apart this whole notion that AR-15s are akin to machine guns, and use that to put the issue in front of the court? And so that's what we did. And so there's a brief by the Second Amendment Law Center, the Second Amendment Defense and Education Coalition, the FFL Illinois, Gun Saves Life, to sit there and put the issue of there should be a narrow ruling, because if there is not a narrow ruling on the ATF rule on bump stocks, then you might as well take the Seventh Circuit's opinion that AR-15s are akin to machine guns and therefore can be banned. And with a rule, ATF could just put the entire class of magazine-fed semi-autos like AKs and ARs and put them under the NFA with a swipe of their pen. And that's what the brief talks about. And so we use the brief to point out that that is exactly what the ATF is attempting to do with their new frame and receiver rule in Vanderstock. And that is also what the Seventh Circuit has done. And if you do what ATF has done in the Vanderstock rule, and then you give ATF data power and ability, just like they are saying that bump stocks now qualify as machine guns, we are one rule away from saying that AR-15s within an ATF rule are readily convertible to being put under the NFA. And so we used that rulemaking to point out, because that's what the Seventh Circuit said in their decision in Beavis back in November. And so it was like, hey, why don't we use this to bootstrap and get our way in front of the court and lay out all the flaws of the Seventh Circuit? That the Seventh Circuit, but for, they say AR-15s are the same thing, even though they don't have a selector switch, even though they don't have all the parts, they are virtually the same thing as a machine gun, and therefore can be banned, because that's how they read Heller. And so this is the second time in as many weeks that the FFL group and people represented by Chuck Michel's law firm are in front of the Supreme Court, asking them to, one, rule narrowly on the Cargill case, that there is ATF doesn't have this, that ATF has to stick within because they need a narrow definition. And then here we are up again in another petition, this time asking for certiorari that they accept our case. Now, mind you, so there's a lot of pieces to the puzzle. It's like a giant game of Tetris or Jenga, and we got all these things, and they're starting to fall into place. So back in November, they said they were going to take up the Cargill case. Little did we know we were going to get such a shitty ruling out of Judge Easterbrook, and Frivolous Frank was going to double down on his Friedman case from 2015 with the ruling we got on the consolidated cases here in Illinois. And then the court said they're taking up Cargill. Great. How do you talk about bump stocks without talking about semi-autos? I don't know. It's going to be, the Justice Department tried to do it very masterfully in their brief, but I want to see what the questions at oral argument are, because now you had the Bianchi case. We had waited over 13 months for a decision. Everybody thought we were going to get a decision out of Bianchi. We were going to get a good panel decision. It would probably go en banc. The en banc people would play games with it, and then we'd be back up in front of the Supreme Court. Remember, Bianchi was one of the 4 cases that were GVR'd when Bruin came down, the New York State Rifle and Pistol Association. V. Bruin came down. I hate calling it Bruin. And with that, so you got Bianchi. And then lo and behold, taking a page out of the Ninth Circuit's playbook, what do? They don't issue an opinion for 13 months, and Bianchi then magically goes straight en banc after us waiting over a year. And so now Bianchi has filed a petition for cert before judgment, and they've got their issues in front of the court saying, we can't get a fair shake. Now, people thought that might happen in the Duncan case after all of the Mickey Mouse games that were being played over there. I still continue to believe that Jim Jordan should hold some hearings about the subject matter on how the Second Amendment is being treated in the appellate court and the games that are being played behind the scenes, but that's another video. So now you've got Bianchi has filed a cert petition. Cargill's up for orals in a couple of weeks. You have the amici coming in for Cargill. Now you have the Solicitor General filing for a cert petition on Vanderstock because the Fifth Circuit Court of Appeals called them out for what they were trying to do in their overly broad rule to regulate frames and receivers and parts, which they have no authority to regulate parts. And they've taken a view that unfinished parts qualify as frames and receivers. So they're feeding right into what we were pitching in our amici brief to the Cargill case. And then on top of that, you now have the cert petition for the Illinois gun ban cases pending in front of the Supreme Court. This stuff is stacking up like a flight, like a flight pattern coming into an aircraft carrier on night quals. This stuff is stacked up, and it's interesting. It's good. I really like the brief that got submitted on our behalf here in Illinois to the Supreme Court, our petition for cert. I like the amici brief that we filed in the Cargill case. I think the Bianchi lawyers just knocked it out of the park in what they were trying to accomplish there. It would be great if we got something out of the Ninth Circuit to where we had somebody just blow the whistle over there and just call a spade for the shenanigans that are going on. We've already got Justice Van Dyke's comments and his dissenting opinion from the en banc panel ripping this right out before the three-judge panel got another bite at the apple. So that is everything that is going on out here. And just wanted to share this with you, some breaking news this afternoon, and put all of these dots in a row for you to look at, because you know what? It ought to be a Margarita Monday for some of this stuff that's coming out here. Now, we'll see what the court does. They could take one of them. They could combine a couple of cases. But I think it is getting too deep to ignore for the Supreme Court. And we'll see what they do. Guys, as always, please like, copy, subscribe, copy and paste the link to this video around on all your social media sites. And we really appreciate all the support for my family and the things we're going through. And as always, frag out.